and gentlemen, distinguished guest and book enthusiast, I, Bhumika Indulia, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to release the 8th edition of Ahmad Siddique's book, Criminology, Penology and Victimology, revised by Mr. Sanjay Vashishtha. Published by EBC, this book delves into the topic of crimes in the Indian context, providing a comprehensive analysis from an individualistic to an environmental approach. It sheds the light on various aspects of crime and aims to create awareness and understanding amongst readers. As we gather here today to celebrate the release of this important book, allow me to first welcome the dignitaries on the dais. Justice UU Lalit, it is my great pleasure to introduce you to Justice UU Lalit, former Chief Justice of India and Professor of Law and Justice, a true embodiment of legal brilliance and excellence. While we all are aware of his excellence in the legal field, both at the bar as well as the bench, Justice Lalit is lauded for his short yet impactful tenure as the Chief Justice of India, especially for making significant strides in convening larger bench hearings. Prior to Justice Lalit assuming office, only 10 constitution benches were convened since 2000. His commitment to excellence is further evidenced by his putting into practice the live streaming of larger bench hearings. Even after his retirement from his judicial role, Justice Lalit continues to inspire others by dedicating his life to teaching law to students. Sir, we are honored to have you as the chief guest today. I would like to request our director, Mr. Abhinandan Malik, to felicitate Justice Lalit. Allow me to introduce the illustrious Professor G.S. Bajpai, whose remarkable career spans over 3 decades. Currently serving as the Vice Chancellor of National Law University, Delhi, Professor Bajpai has authored 22 books, more than 60 papers, over 100 op-eds in leading dailies. Professor Bajpai also served as the convener of the Committee for Reforms in Criminal Law set up by the Ministry of Home Affairs, spearheading historic reforms in criminal laws in India. His role as amicus curiae in important cases led to the evolution of concepts like wrongful prosecution and victim impact report. With unwavering commitment to excellence and a passion for the law, Professor Bajpai is an inspiration to all. We are honored to have you here with us, sir. I would like to request our senior editor, Ms. Nilufar Bhateja, to felicitate Professor Bajpai. Please join me in welcoming Mr. Sanjiv Sen, Senior Advocate at the Supreme Court of India and a true inspiration to legal professionals everywhere. With a career spanning over 3 decades, Mr. Sen was one of the 2 advocates designated as a Senior Advocate in the year 2014 and has appeared in several legal cases relating to constitutional, civil, corporate law, insolvency and bankruptcy, etc. In 2003, Mr. Sen was appointed as the first ever standing counsel for the Municipal Corporation of Delhi in the case, Delhi property ceiling case, Upahar Cinema case, fire case, to name a few. As one of India's most accomplished legal professionals, Mr. Sen is an inspiration to all. We feel privileged to have your presence amongst us, sir. I would like to request our senior editor, Ms. Nikita Anand, to felicitate Mr. Sen. A lawyer's role is not just to win cases, but to ensure that justice is served to all. Our next guest, Ms. Menaka Guruswamy, Senior Advocate in the Supreme Court of India, exemplifies the true essence of the legal profession, known for her involvement in advocating for LGBTQ rights in India. Ms. Guruswamy is known for having played a significant role in decriminalization of Section 377, the Augusta Westland bribery case, the right to education case, to name a few. She has also advised the UNICEF on international human rights law and has also supported the constitution-making process in Nepal. An alumna of Oxford University, Harvard Law School, and a National Law School of India, Ms. Guruswamy is a shining example for aspiring lawyers and a true advocate for human rights. We are truly honored to have your presence here, ma'am. I would like to request our editor, Ms. Apurva Goyal, to felicitate Ms. Guruswamy. Please join me in welcoming our esteemed moderator for today's event, Ms. Vrinda Bhandari, Advocate on Record, Supreme Court of India. A first-generation lawyer, Ms. Bhandari handles a wide range of criminal, civil, and commercial disputes with a focus on digital rights and data protection. She also serves as a counsel for the Internet Freedom Foundation. In a profession that is accused for being unfair for first-generation lawyers, Ms. Bhandari has proven herself and is a truly force to be reckoned with. An alumna of Oxford University and the National Law School of India, Ms. Bhandari is also a basketball player and a marathon runner. Truly a remarkable individual. We are truly delighted to have you here with us. I would like to request our editor, Ms. Diksha Dabas, to felicitate Ms. Bhandari. It is with great honor that we now introduce the man of the moment, the brilliant Mr. Sanjay Vashishtha, Advocate, Supreme Court of India, and the revising author of the 8th edition of Criminology, Penology, and Victimology. Mr. Vashishtha has been engaged in several high-profile cases and has also served as a consultant to Penal Law Reform Committee of India, constituted by the Ministry of Home Affairs to amend penal laws in India, and as an expert member of the committee constituted by the Government of India to study law relating to right to repair in India. An alumnus to Oxford University and McGill University, Canada, Mr. Vashishtha is actively involved in various human rights projects across India and is the founder of the think tank Disability Rights and Mental Health Research Foundation in India, that was launched with a quest to address wrongful convictions and provide better access to criminal justice system for persons with disabilities. With this book, Mr. Vashishtha aims to shed light on the various aspects of crime and create awareness and understanding amongst readers. I would like to request our editor, Ms. Nilufar Bhateja, to felicitate Mr. Vashishtha. Established in the 1940s, EBC has been a pioneer in providing high-quality legal resources to professionals and students. Mr. Sumeet Malik, as the director at EBC and associate editor at SCC, has played a crucial role in advancing EBC's legacy to new heights with his visionary leadership. In addition to his contributions to the publishing world, Mr. Malik also holds a position to the head of finance chair at Entrepreneurs Organization, Uttar Pradesh, demonstrating his diverse abilities and unwavering dedication to excellence. I would like to request Ms. Toshika Soni to felicitate Mr. Malik. Warm welcome to all of them and to all our guests sitting right here today. I would like to now invite Mr. Sumeet Malik, Director EBC, to deliver his welcome address.
Chief Justice UU Lalit, Professor G.S. Bajpai, Vice Chancellor NLU Delhi, Mr. Sanjay Vashishtha, Ms. Menaka Guruswamy, Senior Advocates, Mr. Sanjay Vashishtha and Ms. Vrinda Bhandari, Advocates, judges, advocates, and gentle people. It is my privilege and pleasure to welcome all of you to this event, where we will be celebrating the release of the 8th edition of a celebrated work, Professor Ahmad Siddique's Criminology, revised by Mr. Sanjay Vashishtha. I am grateful to Justice Lalit, our chief guest, our panelists, Professor Bajpai, Mr. Sen, Ms. Guruswamy, our moderator, Ms. Vrinda Bhandari, for taking the time out to participate in this event. Criminology is a subject is often not given importance. Our entire thought process regarding crime and punishment has changed or ought to change. I, for one, and I'm sure all of you, look forward to a very engaging panel discussion today. EBC's association with Professor Ahmad Siddique is over 50 years now, since when he was a professor at the Faculty of Law, Delhi University, and my father, Shri Suren Malik, was studying there. That association culminated in the publication of a book on criminology. That book has become the foremost book to study criminology from, whether at the LLB or the LLM level. EBC's association with Sanjay is a little more recent. Sanjay has utilized all his training received at the Oxford University to give a completely new perspective to the subject. He adds to the book all the new development in this area of law, making this edition contemporary, and therefore the book is now aptly named Criminology, Penology and Victimology. In addition to revising this book, Sanjay has authored a course on the same topic, Essentials of Criminology, which is available on the EBC Learning platform. Sanjay has also been at the forefront of assisting EBC combat piracy of its books, successfully getting orders for raids on the counterfeiters' premises and suing giants like Amazon and Flipkart who have been complicit in the selling of counterfeit copies. If you in the audience have attended some of our earlier book releases, you may have heard what I am about to say, but I say it again. So in this new world of technology and artificial intelligence, ChatGPT with all the answers, some correct, some maybe not so, which allows for instant self-publishing, publishing on blogs, etc. The question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustees of legacies of authors. Even though Professor Ahmad Siddique may not be living amongst us, yet by getting his book revised regularly, we hope to perpetuate his legacy. Sanjay is a young author, and we hope that to not only see more editions of this book, but books on more subjects. A book, as I see it, is a custodian of thoughts and ideas, whereas judges, while deciding cases, are bound to decide the list before them on a given set of facts and apply to those facts. Law authors, when writing a book, do not face such limitations. A good author will explain the law to their audience, but a great author will also show the light forward by placing their thoughts and ideas in a book of what they consider the law ought to be. As we at EBC enter the 80th year since our incorporation, what we have learned is to understand what the legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. As a third-generation member of this publishing house, I have been blessed to have been shown the way by my elders. My granduncle and grandfather had very humble beginnings, delivering books on bicycles to lawyers, including the great Mr. Ambedkar, when they started off as booksellers in 1942. But even then, the mission was clear. Provide a service which will assist the practitioner in her work. The mission continued with the same spirit when EBC started publishing books for lawyers and students in 1947. The books we produce must necessarily be of high quality and assist the user in their quest for knowledge. To be effective in our role, it is important that the materials or content that we produce is authentic, accurate, and reliable. Also, we have continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Suren Malik graduated from the Delhi University, having studied by the newly introduced case method, he realized that there was a need for faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases. As you are aware, there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which we have adhered to since then, and we understand and recognize our responsibility that the honorable judges in the bar rely on Supreme Court cases. He, Mr. Suren Malik, has now taken up the onerous task of reporting judgments of the Supreme Court since 1950 till 1968, a period not covered in SEC earlier. In just 10 volumes published, we've discovered and reported many important judgments of the court hereto never reported before. With High Court cases, HCC, our newly launched venture, we begin the journey to report judgments of the High Court of India with the same alacrity and comprehensiveness as we report the Supreme Court. EBC has recently welcomed Company Law Institute into its fold and is now offering the famed income tax reports, ITR, company cases, goods and services tax reports in both print and electronic formats to our subscribers. As soon as publishing shifted to desktop publishing, we at EBC adopted it and shifted our printing from hand-composed type to software-designed typeset to now digital printing, the latest innovation in this field. Print on demand has gotten to the publishing industry before laser printers printed aircraft parts and human hearts. EBC was amongst the first Indian publishers to introduce a legal research database on CD-ROM in 1996, which was less than 650 MB in size, and now on the SEC Online web edition has grown to over 20 terabyte of data, 5 million documents covering over 300 and plus jurisdictions around the world. Even though we believe that the printed book is not going away, yet for the tech-savvy, EBC's EBC Reader platform is ready and has over 400 books, and now we add new ebooks to it every day. The SEC Online blog, on which we report the happenings in court, law schools and the like, has now over 1 million views and over 500,000 visitors every month. It is being relied on by increasing number of legal professionals as a source of authentic and analytical legal news. Constantly innovating, EBC's newest services, EBC Learning, an e-learning platform, and Mercury, a judgment tracking software, are already gaining loyal users. We're also fortunate to have as part of the EBC family a dedicated team of legal editors, software engineers, DTP staff, proofreaders, sales and marketing staff, and managers who are as much, if not sometimes more, invested, ensuring that what is produced in the house of EBC is of high quality, authentic, accurate, and reliable. It has been a wonderful experience working with you, Sanjay, on this book, and we look forward to collaborating with you on more projects in the future. Thank you.
Thank you so much, Sumeet sir. I would now like to request the chief guest for today, Justice UU Lalit, to deliver the address.
The author of a brilliant work on the subject, Mr. Vashishtha, all the distinguished members of the bar who are present today on the dais and off the dais, Mr. Surendra Malik, and everybody present here today, ladies and gentlemen. The subject criminology and subdivided under penology and victimology is a subject which has been engaging attention of almost everybody connected with administration of criminal justice. I recollect one or two cases. Number one, first, it was in Achyutanandan that Justice Krishna Iyer was confronted with a particular problem. And the problem was that there was an acquittal by the High Court on a murder charge, and the state had chosen not to prefer any appeal. And somebody from the family of the victim came up by way of a special leave petition, which on grant of leave was accepted by the court and the appeal was allowed. And the person concerned was sentenced to life. So the convicted accused, then preferred a writ petition which came up before the bench, of which the lead judgment is by Justice Krishna Iyer. And a peculiar problem, because if you consider in a normal societal structure as to who is the actual victim, who is the aggrieved party in criminal matters, is normally taken to be the state, which carries the mantle on behalf of everyone, including the family of the victim. And here state had chosen not to file an appeal, and now the baton was carried by family of the victim. Mind you, it was not something like, in today's world, the victims have been given a specific right of appeal. In those days, there was no right of appeal given to the victim. And it's a brilliant exposition by Justice Krishna Iyer on the point that whether the family of the victim could be said to be, quote unquote, aggrieved party in criminal matters. Because we normally don't subscribe to the theory that eye for eye, nail for nail, or hand for hand at the instance of somebody who has been aggrieved as a result of a crime in question. So that was one. So it shows the approach of the Supreme Court towards the rights of the victim. Very well. Now let's turn to penology. The brilliant exposition which came in Bachan Singh, which reversed the trend, that is to say, from what is normally called the usual regime of death sentence in matters where there would be charge of murder, the reversal, that is the normal or the norm, should be life sentence, and a rarity or rarest of rare idea should be confined only to what is called few cases. Bachan Singh came in the year 1980. 73 came the amendment to CRPC, which reversed the idea that in normal circumstances you must give special reasons why you want to give death sentence. It used to be the other way around earlier. That changed the entire approach so far as penology ideas are concerned. Today at every juncture, we always look at what? The crime and the criminal, before we consider the matter whether death sentence be awarded or not. That is so far as your penology ideas are concerned. Penology is now taking a very, very liberal and very considerate approach. As a student of law, what always bothered me was that Bachan Singh was followed immediately in Machi Singh. And in Machi Singh, if you see the orders which are passed in individual matters, there is one matter where a 6-year-old boy was done to death by the rival group, and everyone was given death sentence. In today's world, you may not find that kind of approach coming from the court. One more facet of the matter. In 2014, Justice Nariman's co-bench in that Muhammad Arif's matter said that every review petition which has been filed by a convict who has been given death sentence must come before a bench of 3 judges. And there has to be an open court hearing. Now that was a complete departure from the normal ideas where the review petitions would be taken by circulation. And the statistics actually show that after that, when the review petitions started coming up before the court, the percentage of affirming what was done by the earlier bench was less than 30%. So therefore, look at the approach and how the development has been taking us in the direction where perhaps I think we are looking at things with new ideas. One more judgment, that was that V. Hariharan, where Swami Shraddhanand came up before consideration by the Supreme Court whether there can be a sentence between the life and death sentence. Whether you can carve out something and say that somebody need not be given death sentence, but I won't award the normal life sentence where, going by Maruram principle, the executive gets a right to commute or remit the sentence after 14 years of actual sentence. So I may curb that, I may restrict that and say that the man may not be released till he completes 30 years, or at least in some cases the court has gone to the extent of saying that not till he breathes his last. Now that is something which has been created by the Supreme Court. So all these developments, what do they indicate? They indicate a different approach which is coming from the judicial organ of the state. Even in cases where, if you see that Shatrughan Chauhan. I was just not able to recollect the name. Shatrughan Chauhan is a judgment which has been rendered by a bench of 3 judges, Justice Sadasivam speaking for the court. And it has catalogued every single item which can be looked into, even in cases where a death sentence is awarded and post-death sentence award, there has been supervening circumstance. So this is where we get to know that if there be delay in considering the mercy petition, if there be lunacy which intervenes subsequently, if there be solitary confinement, where a person has been subjected to solitary confinement, opposed to the principles laid down in Sunil Batra, even in such cases, the court says that we may commute the sentence from death sentence to life. And that shows us the new approach. But there are certain areas which, as a practitioner on criminal side and as a judge, have always bothered me. If you see the old 304, why do I say old? Because now it has been taken over by 3 new legislations. And the old 304, there would be 2 parts, part 1 and part 2. Part 1 would be where the absence of intention or the absence of knowledge would be the relevant factors when you may not grant, when you convert it to what is called culpable homicide not amounting to murder. But the band of sentence, what is available? Under 304 part 1, it used to be life sentence or up to 10 years. So theoretically, it could be from 1 day to 10 years. Under 304 part 2, again 1 day to 10 years. There hasn't been either an indication from the legislature or the parliament as to which are the cases where you may award 10 years, which are the cases where you may award life sentence even under 304 part 1, or cases where you may just award a sentence of fine. There have been such cases, especially in 70s and early 80s, where even when a man had lost life, the accused would be given under 304 part 2 just a sentence of fine. Now that actually puts you in a terrible jam as to what is the level of sentence which needs to be awarded in such matters. As a practitioner, as a lawyer, I appeared in a number of matters, and especially for 2 persons who were coming from well-known persons in social field. One was awarded 5 years for killing a black buck, and the other equally famous person was awarded 3 years for killing a human being. Another client of mine put it to me and said, "So what is the logic? एक इंसान की कीमत जानवर से कम है क्या?" And that's when you realize that perhaps I think in our sentencing jurisprudence, we need to have greater clarity, greater consistency, without there being any ambiguity at any juncture. And that is exactly why what Mr. Sumeet Malik stated is absolutely right. In our normal colloquial parlance, when it comes to lawyers, at the lowest level we say these are pleaders. They plead a particular thing. At the slightly above level, we say they are advocates who advocate a particular proposition. When they become counsel, we say they counsel an idea. They give counsel to the judges. And we have 2 senior counsel here who have attained a status in that field. And therefore you say senior counsel, so therefore they are supposed to be good advisors, giving good counsel to the judges. Perhaps a notch above that are those authors who come out with such brilliant topics and brilliant subject and exposition. So therefore, today we have gathered for launch of this book. I congratulate the publishers, but more than that, I congratulate this young man for embarking on this journey. Good luck to everyone. Thank you so much.
Thank you so much, sir, for your enlightening words. Ladies and gentlemen, it is now time for the momentous occasion that we have been waiting for. I would request Justice Lalit to please release the 8th edition of Criminology, Penology and Victimology, revised by Mr. Sanjay Vashishtha. I would also request all the esteemed guests on the dais to open the packages placed in front of them and hold a copy of the book in their hands. Just one more picture, please. Just one more picture, please. Thank you. Thank you, everyone. Truly a remarkable moment to witness. It is now time for a thought-provoking panel discussion on the topic Contemporary Sentencing Trends in Criminal Law. I would now like to invite Ms. Vrinda Bhandari to take over the baton.
Good evening, everyone. Welcome to this book launch. It's a fantastic book, Sanjay, if I can say so. I completely agree with Justice Lalit. It was really interesting seeing it. And just for the benefit of the audience, I'll just go over some of the topics that has been covered in this book, just for everybody to understand the kind of length and breadth of topics. So there's crime and criminology, and in that, we talk about explanation of crimes, the different approaches, the environmental approaches, individualistic approaches, pre-trial procedures, white-collar crime, prevention of crime, policing, a wide variety of issues, violence, organized crime, female criminality, alcoholism, drug abuse, sex offenses, which was very interesting to see. Then there was Penology, which is part 2 of the book, which talks about different approaches. So punitive approaches, prison reform, probation and flexible techniques, sentencing policies. And then the third part is on victimology, which is victim and crime and victims in the state. So I really do encourage everybody to get their hands on this book. It's absolutely wonderful. Coming to the first question to Justice Lalit, I must say I'm very jealous you never taught us, because you're clearly wonderful at giving expositions on criminal law, and we've all lost out. So you were one of the finest lawyers at your time, of your time, and then you became a judge. And even the example you were giving of Muhammad Arif and the impact it has shows that there is possibly a subconscious change that comes in which judges don't realize. And so I was wondering if you could speak from your personal experience, that while deciding criminal cases or sentences, what was the aspect that surprised you the most, that you didn't expect when you went into judging versus when you were a lawyer?
See, as a lawyer, you put across a point and then leave it to the court. Everybody knows who decided Menaka Gandhi, but very few people know who argued the matter. So therefore, the lawyers are always in the background. Though he may have advocated or projected an idea, it is ultimately for the court or the judges how best they do it and to what levels they take it, the matter. So therefore, the contribution of a judge is of a different dimension than that of a lawyer. As a judge, naturally you have to see both sides, number one. And number two, if I am laying down something, what will be the effect on the progeny hereafter? What will be the effect on the general population hereafter? Whether I lay down something as a principle, will it be something which will subserve the cause of justice? Now, coming back to this Muhammad Arif, it's a, mind you, Justice Nariman became judge in July, and Muhammad Arif comes in September. So in less than almost 2.5 months, Justice Nariman wrote that judgment for the Constitution bench. And what a brilliant idea that, we are in a situation where if the death sentence is to be confirmed, it's an irreversible idea. So therefore, rather than bestowing your attention in a review petition in your chambers, where you consider the matter by circulation, why not put it in the open court? Number 2, he didn't say that very well the same combination may hear the matter. He said, very well, since it's an irreversible idea, let there be an odd number of judges, so that even if there be disagreement, you will have a clarity in the matter, and so therefore before a bench of 3 judges. Good. So we had a peculiar idea where the appeals would be heard by a bench of 2 and reviews would come before a bench of 3. So therefore, on administrative side, the Supreme Court decided that it shouldn't appear that the bench of 3 judges is actually sitting in appeal over that. So therefore, why not list the original matters, the original death sentence appeals before a bench of 3 judges? So therefore, look at how the mind of a judge actually helps in sort of easing the pressure on the system and getting a new dimension to the doctrine of fairness in these matters. Now, coming to the personal note, I'll just narrate one case which bothered me every time, and which still I don't consider whether did I do the correct thing, did I not. I'll tell you what happened in that matter. A man and a woman were in relationship without the marriage. And it was not to the liking of the family of the boy. And they were blessed with a child. And the child was just about 6 months old when the couple along with the child go to a particular temple in southern part of the country. That temple had large land. So therefore they just roamed about in that land. And when they came out, the child was not with them. And this was seen by some of the florist who was there at the door of the temple selling flowers. And he found that this couple, when they went in, they were with the child. Now they are coming out, the child is not there. So he created a ruckus there that, these people have done something wrong with the child. The couple was taken to the police station. And they were asked that, were you with a child? They flatly refused. Their statements were recorded that we were not having any child with us. Very well. After 3 days, some of these stray dogs were having limbs of the child. And then the matter was referred to DNA analysis. The DNA print of that child matched with these 2 persons. They were summoned because their names were recorded in the police station. They were summoned. And they were tried for the offense of murder. But the trial court gave them what is called 304 Part 2. And they were given just about 5 years of sentence. Aggrieved by that 5 years of sentence, the matter was carried right up to the Supreme Court. And when the matter came up before the bench of which I was a member, I was dead certain that they have done something to the child. And that is the reason why the guilty mind was so clear that they actually said that the child was not with us. If the child could be associated with them as by their parents, then where did they leave the child? The persons had seen them with the child entering the temple premises. I had half a mind to issue notice for enhancement, to say that this is a murder. But they were not tried for 302, they were tried for 304 Part 2. Now that becomes a complete leap to be taken by a bench. And that's where I just left it at that. Now at times, I still recollect that and feel that perhaps I made a mistake. Now this is something which, as a judge, because you are guarding the welfare of the society, you are the guardians of that. You must actually have scales of justice in such a fashion that very well you may tilt in favor of somebody when it comes to, say, showing mercy. That's a different thing. But here, I was dead certain that perhaps I think these parents had done something wrong with the child. And what they must have done is, they must have just buried the child. Since they were not with any implements where they could dig, so they had just, created a hole in the earth with their own hands. Naturally, they couldn't go deep down. So therefore, the child was just buried there. And because it was on the surface of the earth, these stray dogs could actually dig it and get to the flesh of that child. Now, this is something, this bothers you like anything as a judge. Now, these are the matters where perhaps I think you feel that, the law is not what it ought to be. Correct? Yes.
Thank you, sir. That was such an enlightening answer, and I think would be a great question for everybody to think about how they would go through it. Professor Bajpai, on to you. I think, even the story told to us by Justice Lalit makes us understand the importance of sentencing and, what role sentencing plays. So I was wondering, in your career, you worked a lot on this, from all sides. And what is your view on the sentencing trends as they are currently present in India?
Thank you, Vrinda. Before coming to the sentencing, I first must congratulate to Sanjay for producing this book. और मेरा तो एक्सपीरियंस ऐसा है जैसे हम लोग एक प्राण प्रतिष्ठा के माहौल में हैं यहाँ पे. वो same experience we are drawing. We are launching this book. It's such a wonderful thing because I understand that producing a book means bringing a lot of transformation in yourself first. Then you begin attaining the authorhood is a tremendous experience. So Sanjay, I understand that you are privileged. And we, when as a reader interact with that book, it has a capacity to change your thought process. It creates a metamorphosis in you. That is the beauty of the book. And some books are so apt to do that. Now coming to this question, and also I'm tempted to comment on one more thing, that this book is dedicated on criminology. And the connection of criminology with criminal law is just so fascinating. And therefore, I think it must be underlined, because I always believe that, because I have pursued criminology in my studies mostly, and I believe that when I contrast criminology with criminal law understanding, I feel that criminal law provides you a framework and it limits your imagination. And criminology liberates you in certain sense, where you are free to conceptualize those things which are dealt under the purview of criminal law. And therefore, I believe that the contribution of criminology in terms of knowing and debating on sentencing is very big, because sentencing issues have been first deliberated, debated within the field of criminology before they have been, and that's why criminal law could not so far completely absorb those kinds of understanding, because in India the tradition of having a behavioral approach to laws have not evolved, and criminology is essentially a behavioral science. So if you are on sentencing, it means you need to look at the factors which are aggravating or mitigating. You need to create those set of factors which are criminogenic and which could be relevant for the victim. But three things are very important as far as sentencing question is concerned. I will come back to this criminology discussion as such later. I believe that in India, the biggest problem in the arena of sentencing has been that we couldn't institutionalize the sentencing structures and framework in our context. Despite the fact that Supreme Court quite regularly has been talking about it, Law Commission has been talking about it. So generally we find there are two types of approaches. One which says that there should be a standardization of sentencing, which is mostly the US kind of model. And other is, which this book is also talking about, the individualization approach. Now we are still struggling as to what could be the best format for us, whether we should have a standardized guidelines like on the US model, or we should have a very individualized approach like our mixed approach that UK follows. And because there are a lot of disparities in Indian context, and we try to devise those mechanisms through which we could address those disparities in sentencing. So I believe that there is a need to really create a framework. And before 73, the sentencing hearing was not at all there. We have introduced 235 to where sentencing hearing happens. But I wish to make a suggestion, and as a part of Criminal Law Reform Committee, I tried to pursue this. Somehow it couldn't happen. Let me put it very clearly. We have suggested let there be a provision dealing with the mechanism of sentence hearing. Mechanism of sentence hearing has not been spelled out clearly in the law. So how the sentencing hearing would be seen? So same day conviction, same day sentence hearing, I think some time should have been provided there, so through which the material can be adduced to the court in support of a particular mitigating factor or something like that. So sentencing hearing mechanism has to be clearly instituted. That is my first thing. Second is there are various other things which have recently come. This book is also talking that in Delhi High Court, the Karan versus NCT was decided, where the High Court has introduced the victim impact report. Why can't victim can also be heard on the question of sentence? When you provide an opportunity to hear the convicted person, you can also provide the same opportunity. In fact, in all other European jurisdiction, the victim impact report is prepared by the prosecution, and same is produced for two main objectives. One is the quantum of compensation, other the quantum of punishment. Unfortunately, there is no occasion to really hear the victim as a matter of obligation on the part of court. And now you have introduced community sentence. Now this can also be one of the sentencing options. But again, you need to clarify how all these things have. So these are some primary issues with regard to sentencing in India. And criminal behavior, unfortunately, the criminal law provides very limited lenses to understand the dynamics of criminal behavior. In India, the kind of criminality that we are seeing today, I always find very recently, crime has become a power resource. And people are criminally enabled in a way. And they have lot. So how all these things will be factored when sentencing is, heard, sentencing issues are heard on the part of the court. So those things, criminological insights can become very, very useful, because criminal behavior is not that simple. It's a very complex thing. And we have so far understood crime and criminal laws from the lenses of the state. So state has provided us a framework, and we have imbibed that, and we think that it is like that. However, the things are, though I am reminded, sorry if I am extending the time, I am reminded that Stephen Box said there are two types of crime. Crimes of repression and crime of reaction, resistance. So a lot of criminality we say is a matter of repression. Recently a very nice article has come up which is talking about essential crimes, during COVID. And how criminal law is then applied to deal with all these things has become a power mechanism exercise mostly. So it is in that sense I said a lot of critical criminality or critical criminology has come up, which should, because, Douglas Hussack said criminal law should be a last resort. But we could not devise multiple options because we have conceptualized, that is our whole problem. Criminal law is simply a pain delivery mechanism. You need to provide certain pain because person has done. But you do not have many options in that case. What could be those options? Harvard Law School Dean Martha is talking about forgiveness. People are exploring the connection between law and happiness. So criminal law is no longer restorative. That is the whole problem. And whereas the person is seeking certain restoration, certain re-engineering of society. So I think we in our sentencing options are failing to understand what kind of positive obligations criminal law could create on the part of society. And that's why you'll see these short-term tricks are happening where preventive role of criminal law is more and more put into action, where we want somehow people to be arrested and somehow registered for a while. And that is not really happening. So I think the criminological insights are going to be very, very vital in terms of creating. Unfortunately, criminal law reform happened, but sentencing chapter could not come up the way we wanted, despite the fact that the Law Commission has been talking about Supreme Court, case after case has been saying it is the time to really provide at least some guidelines, statutory guidelines to take care of sentencing option. Because sentencing in this country has always only been discussed and confined in the context of death penalty. But sentencing is equally important in all other categories of offences. But somehow that is not happening, and more so at the trial court level where everything has to happen. Unfortunately, the capacity of the system is lacking miserably to appreciate and underscore those things which are very, very crucial as far as sentencing is concerned.
Thank you so much. That was really a tour de force of an answer. And in fact, that leads me to my next question, sir, Mr. Sen. Professor Bajpai spoke about the positive obligation on criminal law, the fact that sentencing has not always panned out, to speak about how there is a more preventive aspect that is now being used for criminal law. Given this context, how do you see the existing laws as they have been implemented? Have they panned out according to you in a manner that they should have? Are there any trends in sentencing that have particularly concerned you?
You see, the first aspect is the aspect of punishment. Now, the Indian Penal Code prescribes various forms of punishment. One is by death, one is the death penalty, one is life imprisonment, one is simple imprisonment, one is taking away of property, and one is fine. And now the new law which has come, which is the BNS, has added one more form of punishment, which is serving society, community service. Now, as far as the extent of punishment, type of punishment, relationship of a punishment to a crime, that is within the domain of the legislature. Now, which punishment should be given to which crime and to what is the year band is what the legislator is supposed to decide. But here, there are some interesting aspects which the legislature in our country has, sadly not really addressed and has been quite arbitrary. Like, for example, a criminal, the sentencing as far as the kite flying. If you fly a kite and if that injures somebody, that can carry out imprisonment of 2 years. Whereas if you grievously hurt somebody, that can give you a punishment or a sentencing of 3 months only. Another example is, say, of ragging. In the state of Andhra Pradesh, offense of ragging can give you 10 years, whereas in the state of Uttar Pradesh, offense of ragging can give you 2 years. Now, this kind of arbitrariness is something which the legislature has unfortunately not really addressed and not really, straightened out. And the other aspect is within the band of punishment, what is the exact punishment, or what is the exact sentencing to be given in each and every individual case is within the ambit of the judiciary. Now, as far as the judiciary is concerned, I read an interesting article a few years back by Abhinav Chandrachud, where he compared two very interesting cases, both of death, both of murder. One was, if you all remember, the murder of Graham Steens, the Christian missionary, after a protracted trial, the accused were given a sentence of life imprisonment. Whereas in case of a honor killing, I think the case was Bhagwan Das, the Supreme Court was awarded a death penalty. Now, in which case a death penalty should be given, in which case a sentence for life should be given? I mean, what is that rarest of the rare case? What are the factors to be brought into it is something which is still, I would say, quite arbitrary. There is no system. There should be better guidelines, both on aspect of the sentencing, both by the legislature and the judiciary. So therefore, a lot remains to be done, and this arbitrariness requires to be addressed on both levels, and of course, I mean, the new law which has come is I mean, overall more or less following the trends of the earlier law as far as the sentencing is concerned. But in this regard, I must congratulate Sanjay Vashishtha for a fantastic revision of the book, which is, I think, only one of a kind in this country. Criminology, you've done a fantastic job. Congratulations, and I'm sure everybody will benefit from the.
Thank you so much, sir. So you spoke about, the importance of the aspect of sentencing by legislature and judiciary and bands of sentencing. And I think that brings me to the question, Dr. Guruswamy. How do you think AI will play a role, whether on the judicial side, on the legislative side? I mean, we are seeing a lot of developments of new age technology and artificial intelligence. So, what is your perspective on the role of AI and how it could help the judiciary?
Thank you, Vrinda, for that. And I must start by congratulating Sanjay. Sanjay is very much a lawyer's lawyer, but he's also very much a thoughtful scholar. We did a very difficult case in the morning today for the state, and we do many such cases together, and it's wonderful to see young lawyers melding both these worlds of scholarship, deep thought, and legal practice. So congratulations for this book, which for all of us who practice criminal law was a welcome addition. It's a revised version. But congratulations also as a member of the bar, for being part of both these worlds. Vrinda, your question, I love talking about artificial intelligence. Look, I think there are 2 or 3 different aspects to this. One facet to this is in many countries, as we were just chatting, artificial intelligence is being used to adjudicate, if you will, for lack of a better word, because that's what the software is doing, is being used to adjudicate issues like parole, issues like hiring decisions, termination decisions are now being used by artificial intelligence, are being done by artificial intelligence. Over 25 years ago, in a different life, when I was a mergers and acquisitions lawyer in New York City, I spent my first year as a law associate doing due diligence for large transactions. Today, all of that is done by software and AI. So law firms in the West are in fact hiring way less than they used to. So you will see a refashioning of the legal profession, because artificial intelligence will replace a lot of lawyerly functions that human beings were performing. Right? So that's the first facet. The second facet is, artificial intelligence will also replace a lot of routine facets in adjudication. Traffic court, illegal occupation of land, Sanjay, what we did today. Cannot artificial intelligence make that assessment? Could the court process today not have been spared? Sanjay and I are very happy the the case went to court because it means we got paid. But, having said that, as someone who is interested in, public spirit of the law, and there's a former Chief Justice here. So I think that, you will see AI, playing these roles. And AI itself will have many of the biases of the programmers who have created that software, right? So you will see different facets of this. Something I found incredibly interesting, Vrinda, is I read a case. It's a new case. It's just come up last week, I think, or maybe 2 weeks ago, where more and more young people are living in the virtual world. So in this virtual world, like Meta or what have you, you adopt an avatar, you have a life, you make friendships, you exist in that world. Young people are existing in that world for substantial parts of the day. You are buying, you are selling, you are transacting, you are becoming parts of groups, you are making good friends, and your avatar, who you now associate with and are fairly, you have an intimate association with this version of yourself, is assaulted by a group of male avatars. And this person is a young woman. What has just happened? What is this world that is being inhabited, right? Is that the virtual world? Is that the real world? Because I invest in my avatar, right? I invest not only financially, but I invest emotionally, intellectually. I live in a certain world. What is crime? Is it that I must be stabbed? Or can something happen to me in this virtual world which injures me also? So this idea of what is crime, who is a criminal? In cybercrime, what is happening? In identity theft, what is happening? Something that Vrinda and I were chatting about, surveillance. How are we investigating when we're looking at facial recognition? What is the premise of that? Eventually, criminal law's final frontiers will be simple. It is in which world will the crime have been committed? In which other world does the criminal live? And are you being heard and adjudicated by an algorithm or a human being? I'll leave you with that thought.
Very prescient thoughts. I would love to revisit this 5 years later to see where we've reached. But I think coming to you, Sanjay, the man of the hour, fantastic book. If you could shed some light on what prompted you during this to revise this book, and some of your biggest learnings that came out from this book.
Thank you, Vrinda. I mean, I thought you would have a legal question, and I was anticipating an answer. All my thoughts have gone into the book. I would leave it for the readers to then decide on this. But obviously, I did my master's in criminology at Oxford. So I recall, I think it took a while. We started in 2019. Mr. Abhinandan Malik, who sits in the front, right here, he in fact requested me if I could perhaps update this book. And when I started, reviewing the book, it was as if, we'll have to really, not only modify it to meet, the requirements that has obviously now stemmed up, but we tried converting this book into a living tree book that would obviously be one, subjective to every reader, two, something that would enable the future generation to understand what Southern criminology is all about. We need a special criminology to deal with our special problems. So this book is not limited to notions of criminology, but this allows a reader, to decipher criminology and experience the world of criminology in a subjective manner. And that perhaps should be labeled as evidence-based criminology. We need policy framework which perhaps emanate from evidence-based approaches. We have acid attacks. What leads to an acid attack? Acid attack is a subsequent offense which is preceded by preliminary offenses like eve teasing, stalking. So the root cause is obviously required to be addressed. So this book is all about evidence-based policy making for India. And the focus is on Indian criminology or Southern criminology as I label it. Thank you.
Thank you so much. We'll open it up to audience questions, maybe 2 or 3 questions, and then I request all the panelists to answer those questions as you feel fit, and any concluding remarks for 1 minute each, since I know we're out of time. So if anyone has any questions, you can give one of these mics, Bhumika. We'll take 2-3 questions and in one go. Anybody? Does anyone have any questions? No? Okay, if not, then what I just request the panelists to do maybe is, we've had a very fruitful discussion. We've spoken about sort of some of the problems with sentencing laws in India, some of the problems of the court's approaches and the difficulties. And if you could all give some concluding remarks, and also any thoughts on the way ahead. Where do we are now getting 3 new criminal laws. Where do we see the next sort of frontier? Like, should the focus be more on like a sentencing? Is it on training? How do we see the future? So I would love any thoughts, concluding remarks from each of our panelists. Justice Lalit, I'll start with you.
If it's going to be just one remark, then I may just touch upon the facet which was dealt with by Professor Bajpai. And that is to say, the sensitizing our judicial organ at the lowest level. Because that's the first interface with a criminal in all these matters. And it is true that a lot of training is required. I've been going to National Judicial Academy and keep on giving lectures. I'll give you one instance. There was one group of judicial magistrates from Sri Lanka who were to be taught at National Judicial Academy. So there were about 20 odd such judicial magistrates who were taking part in the training process. They were accompanied by what is called 3 district judges, 2 judges of the High Court and 1 Supreme Court judge. So the training was meant for only judicial magistrates. And then I asked that, who was the judge of the Supreme Court, I said, why are you here? Because this is not something meant for you. And the judge said that we would like to know what kind of approach you adopt, what kind of lessons do you come out with, what kind of interaction you have with my students so that I can learn it and then thereafter, revise it so far as my own conditions are concerned. And that kind of, the integration from top to bottom is something which is missing in our country. I have seen from either this side of the bench or the other, I have seen some disconnect between judges of the Supreme Court and judges of the High Court. I have seen disconnect between judges of the High Court and judges of the lower judiciary, and tremendous disconnect between judges of the Supreme Court and the district judiciary. Mind you, if there is a good brain surgeon who operates on the brain, to see his operation, there would be everybody right up to the students who would come to watch that particular operation. So there is an integration which always happens in that particular stream. Take for instance, in army or military, if you have one particular regimental center, even the OC, that's the officer commanding, and the lowest of the ranks, they would all integrate together. Unfortunately, we don't have that. We need to build that so that all the persons who come from the lowest levels will know what exactly should be the approach in these matters, what is the approach which the superior judiciary applies in these matters, and therefore there must be good educational facilities and opportunities for that. So that's one concluding remark which I may offer. Yes.
Please, if there are more, we would, I think, love to hear it. Hear those remarks as well. Professor Bajpai, over to you. If you have any thoughts, and if also any of the panelists wish to speak on maybe how we could balance, presumption of innocence, free, investigation, the judicial process, and how the entire criminal process goes, that would also.
So more substantially on this particular contribution and some important takeaways. I take it from my own experience, because when I started teaching criminal law in universities, I relied on my criminological understanding of the laws. And I devised a phrase that criminological reading of criminal law and victimological reading of criminal law. This we hardly do, because as I am saying, our criminal law is more and more textual. It doesn't have a very clear-cut context. So traveling from rhetoric of the law to the reality of the law is something what this criminology can contribute to. When I say victimological reading of criminal law, I have developed an entire understanding and paper on it. I'm saying we have forgotten the fact that the victim is the main person for whom the entire criminal law regime stands for. But it has been so sidelined in the system that there are very limited opportunities for the victim to have a voice. Providing voice to the victims of crime is a very important function of criminal law.